Hi, I'm Scott Stork with Polaris Law Group in St. Charles, Missouri. I'm an estate planning attorney here, and I want to talk to you today about something that's pretty near and dear to my heart, which is how do we plan for people who have minor children? So I've got two younger children, and there's a lot of considerations when we do plan for families who have young kids. The first thing is, how do we deal with who's going to be the guardian? So God forbid the parents die, or I die, my kid's mom dies. What happens then? We don't want that usually left to having a court make the decision on who's going to raise our children. So in advance, we typically want to name guardians about and state who it is that's going to actually raise the kids. So in my case, I've picked those. We work with many families, and one of the big considerations is who's going to raise our children. Now, how that happens if we don't say who that is in advance, and how that happens if we do using estate planning, are two very different things. If we don't say in advance who's going to raise our kids and we pass away unexpectedly, then the court's going to make the decision on who the guardian is. That is not what most people want. I know that's not what I want. So how we plan in advance is we use wills, last wills and testaments, and that's a very important document in that we can state inside of it who that guardian is or guardians. So typically we want to name a backup to the original person that we pick. So in my case, I've named my brother as my guardian if something happens and there's no one to raise my kids. So my brother and his wife would do that. Now, for most people, picking that person is usually a family member, but that's a conversation to have, is who do we want to raise the kids? Is the person that we're picking far away? Do they live in a different state? Things like that. So there's a lot of considerations when we counsel clients and work with them to figure out who makes the best guardian. Now, using a will and naming the guardians inside of it still means we have to go to probate, but what it doesn't mean is that the judge is going to just have to pick someone based on who kind of wants to do it. We've stated that in advance. It helps kind of grease the skids to make it easier for the court to give that legal authority to the guardian. Now, guardians are probably the biggest issue that we have to think about. But the other issue when we have minor children is what happens to the things that we leave to them. What happens to our assets, to our property, to all those types of things. Now, the big thing to know is that minors, until they're the age of majority, cannot own property legally. So if I leave an inheritance to my kids, they can't own that in their name. And so there's a lot of different ways that can look. But by and large, what happens is, again, the court has to get involved to determine what happens to the property. Now, many people have heard of trusts, some people haven't. Trusts usually are the way that we get around this and avoid having the court have to make these decisions. Now, there are two types of trusts that you will see, or that people see. One is called a testamentary trust, which is a trust that is inside of a will. The problem with that is that you actually have to go to probate to have the judge okay the trust, and then that trust has to be set up, and so there's additional time and things like that are going to be taken that's going to mandate a probate process. There is also something called a standalone revocable living trust, which is what we would use most times, which is just something that can hold the property for your children's benefit, so that there is no probate process to set up the trust itself, and then the assets and property that you own can be collected by the trustee of this trust, who is the person in charge of the money, and it can be used for your kids' benefit much more easily. Who should be the trustee is kind of the next thing. So do you pick the guardian so that who's raising the kids is also in charge of the money? Do you not pick the guardian as the trustee and name somebody different to be in charge of the money? All of that is very dependent on your personal situation and who you're picking as your guardian and things of that nature. So a lot of times we'll see and counsel clients that picking the guardian as the trustee is fine. Other times, we have some people who don't want that close connection. They want their guardian to raise the kids, but maybe that guardian's not as good with money as they would hope. So that they'll oftentimes pick an independent, different person to be that trustee. There's no one-size-fits-all solution to this problem. This is a big issue, something that we don't want to leave to chance, something that we really want to prepare for in advance. And who we pick and what that looks like with guardians and trustees and how our kids are going to inherit and things like that is usually not just a one-stop, one-size-fits-all kind of thing. Our lives change, all sorts of things change as we go forward. So while this is good to set up initially, we really want to be considerate of the fact that we need to make changes to this, update it, look at it routinely to make sure it still meets your wishes. So if you are a younger person and you've got a young family, or even if you've got teenage kids, there is planning that needs to be done. Most people think estate planning is just for older individuals, and that's absolutely not the case. So I hope this was helpful. Again, my name is Scott Stork with Polaris Law Group. You can reach us at 636-757-3850 or find us on the web at polarisplans.com. Again, if you'd like to make a consultation, if you'd like to talk to us about this, we'd be happy to meet with you.